Supreme Court 8-1 gun ruling just changed the rules for your Second Amendment rights. But the part most people missed is this. It also affects your First Amendment right to speak, organize, and fight back. Quick question before we continue. Are you subscribed? Because what I am about to explain could help you understand where your gun rights are strong, where they are weaker, and where the government may try to pressure you without passing a single new gun law. Hit that subscribe button now so you do not miss the next update. Here's what just happened. The case everyone is talking about is United States versus Rahimi. The Supreme Court ruled 8-1 that the federal government can disarm certain people who are under domestic violence restraining orders. Now, before you panic, listen carefully. This was not a ruling that says the government can take guns from anyone based on a rumor. It was not a ruling that says the Second Amendment is dead. And it was not a ruling that says every gun control law is now legal. Let me say that in normal English. The government does not need to find an old law that is copied word for word. But it does need to show a real historical tradition that supports what it is doing. That is a big deal. Because now, when a state defends a gun law, it will say, we do not need an exact match. We only need something close enough. And when gun owners challenge that law, they will say, close enough is not enough when a constitutional right is on the line. That fight is going to decide a lot of cases. But here is the crazy part. This ruling is not just about guns. It connects directly to your First Amendment rights too. Why? Because the same government that may not ban your gun directly could try to pressure banks, insurance companies, websites, payment processors, or social media platforms to cut you off. And that brings us to the second major Supreme Court case you need to understand, NRA versus Vullo. In that case, the National Rifle Association claimed that a New York official pressured banks and insurance companies to stop doing business with the NRA because of its pro-gun speech. The Supreme Court said the government cannot use threats, but the government cannot say, nice business you have there. It would be a shame if our regulators started looking harder at you because you work with gun rights people. That is where persuasion becomes pressure, and pressure from the government can become censorship. So here's the bigger picture. Rahimi tells us how the court may review Second Amendment limits. Vullo tells us the government cannot attack gun rights groups by choking off their speech, money, insurance, or business partners. Together, these cases show the new battlefield. It is not just about banning guns. It is about controlling who can own them, who can talk about them, who can fund gun groups, and who is allowed to be part of the gun culture without being punished. If you are finding this helpful, imagine what you will learn in my next video about the 5 words that can protect you when cops ask about your gun. Subscribe so you do not miss it, because one sentence at the wrong time can turn a simple traffic stop into a legal nightmare. Now, let me break down the Rahimi case in plain English. Rahimi involved a man who was under a domestic violence restraining order. The court did not say every person accused of something can be disarmed. It focused on people who received court process and were found to be a credible threat. That word found matters. It means there was some kind of legal process. A judge was involved. There was a court order. This was not just a random person making a phone call and saying, I do not like this guy, take his guns. Now, does that mean all red flag laws are safe? No. Does it mean all domestic violence firearm bans are safe? Not always. Does it mean the government has a blank check? Absolutely not. This is where most people get it wrong. Some anti-gun politicians will read Rahimi and say, the Supreme Court approved gun control. That is too broad. Some gun owners will read Rahimi and say, the Supreme Court betrayed us. That is also too broad. The truth is more complicated. The court kept Bruen alive, but softened how strictly some lower courts were applying it. The court said judges must look at historical principles, not just historical copies. Here is a hypothetical example to explain this. Imagine your state passes a law saying nobody can carry a firearm within 5 miles of any public park. That law is huge. It covers most of the city. It affects normal law-abiding people. The state might say, we found old laws about guns in sensitive places like courthouses and polling places. But you would say, a park is not a courthouse. 5 miles is not a building. This law wipes out carry rights in normal public areas. Under Rahimi, the court would ask whether the old laws and the new law are similar in why they exist and how much they burden your right. That is the new fight. The words why and how are now critical. Why is the government passing the law? And how hard does the law hit your right to keep and bear arms? If the why is public safety, that alone is not enough. Every gun law claims to be about public safety. The real question is whether history supports that specific kind of restriction. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Now, this is where it gets interesting. The First Amendment side may be just as important as the Second Amendment side, because sometimes the government does not need to ban your gun if it can make owning a gun impossible. Think about it. What happens if gun stores cannot get credit card processing? What happens if gun ranges cannot get insurance? What happens if gun rights groups cannot use banks? What happens if online platforms suppress firearm training videos, legal updates, or gun rights advocacy because regulators are leaning on them behind the scenes? That is not a normal gun ban. But the result can feel the same. You still lose access. You still lose information. You still lose your ability to organize. And that is why NRA versus Vullo matters. The Supreme Court basically said government officials cannot use their power to punish a private group because they dislike its speech. That protection is not only for the NRA. It applies to groups across the political spectrum. Today, it may protect a gun rights group. Tomorrow, it may protect a church, a protest group, a newspaper, or a civil rights organization. That is the point of the First Amendment. It protects speech the government does not like, because speech the government likes does not need protection. Hey, 73% of people watching right now are not subscribed. Do not be part of that group. Join the thousands of gun owners who get these updates first, without the media spin and without the legal confusion. Click subscribe right now. Let us talk about what this means for you in real life. First thing, if you are a lawful gun owner, Rahimi does not mean your guns are suddenly illegal. Do not let fear-based headlines trick you. This case was about a specific federal law. It dealt with people under certain domestic violence restraining orders. The court did not say normal gun owners can be disarmed without due process. Second, if you are involved in any court case, restraining order, protective order, or domestic dispute, you need to take firearm restrictions seriously. Do not guess. Do not assume. Do not say, well, I still have my Second Amendment rights, so I am fine. That mistake can destroy your life. Federal gun laws are serious. State gun laws are serious. And sometimes a court order can trigger restrictions you did not expect. Imagine this scenario. You get into a bad breakup. Your ex files for a protective order. You think it is false. You think it is unfair. You think it will get dismissed. But while that order is active, you keep carrying your pistol like normal. Then you get pulled over for a broken taillight. The officer runs your name. The order pops up. The gun is in the car. Now your simple traffic stop could become a federal firearms case. That is the kind of mistake that can cost you your rights, your job, and your freedom. Third, if you're a part of a gun club, gun rights group, training company, gun store, or online firearm community, the First Amendment side matters a lot. You should be watching for government pressure campaigns. Not every bad business decision is unconstitutional. A bank can decide it does not want certain clients. A private company can make its own choices. But if a government official is threatening, pressuring, or using regulatory power to push companies away from gun-related speech, that is different. That may be a First Amendment problem. Here is what most people get wrong. They think the First Amendment only protects your right to post online. No, it also protects your right to associate with other people. That means joining groups, donating to groups, supporting causes, sharing ideas, organizing political action. Gun rights do not survive if gun owners cannot talk to each other. The Second Amendment protects the right to keep and bear arms. The First Amendment protects your ability to defend that right in public. You need both. Without the First Amendment, the government could silence gun owners. Without the Second Amendment, the government could disarm them. That is why these cases belong in the same conversation. Now, here is the part that shocked me. The court is warning both sides. To anti-gun officials, the court is saying you cannot censor gun rights speech through backroom pressure. But to gun owners, the court is also saying, do not expect every gun restriction to fall just because there is no identical law from 1791. That means the next few years are going to be messy. Lower courts will fight over what counts as a historical tradition. States will test the limits. Gun rights groups will sue. And some laws will survive while others fall. So what should you do? First, stay updated on your state laws. Federal rulings matter, but state laws can change fast. Second, keep records if you run a gun-related business or group and you believe you're being targeted. Emails matter. Letters matter. Official warnings matter. Public statements by regulators matter. Third, do not treat internet comments as legal advice. I know everybody online has an opinion, but if your freedom is on the line, get real legal help. Fourth, understand that rights are connected. Your right to own a firearm is stronger when your right to speak is protected. Your right to speak is stronger when people can organize without fear. And fifth, do not wait until you are in trouble to learn the rules. The worst time to learn gun law is after the cuffs are already on. This information could literally change again before January 2026 as lower courts apply these rulings and states respond with new laws. Subscribe now, because the next video explains exactly what you need to watch for before those deadlines and new rules hit. So here's the key takeaway. The 8-1 Rahimi ruling did not erase the Second Amendment, but it did change how courts may judge gun restrictions. And the First Amendment ruling in NRA versus Vullo reminds the government that it cannot secretly punish gun owners, gun groups, or pro-gun speech through pressure campaigns. If you care about your rights, you can not only watch gun bans, you also have to watch speech, banking, insurance, court orders, and government pressure. Hit subscribe before you go, because staying informed is one of the simplest ways to protect yourself and your family. And remember, this video is only general education. It is not legal advice. Gun laws are different in every state, and your facts matter. If you have a real legal problem, talk to a qualified attorney before you make a move. The Supreme Court decision is a major milestone for legal interpretation. It marks a shift in how historical analogs are evaluated in the courtroom. Lawyers on both sides are now preparing for a wave of litigation that will define the boundaries of the Second Amendment for years to come. Meanwhile, advocacy groups are ramping up their efforts to educate the public on these complex constitutional issues and their everyday implications. It is essential to recognize that legal precedents are often refined over multiple cases and years of judicial review in lower courts. The interaction between the First and Second Amendments creates a unique legal landscape where speech and property rights intersect constantly. Many legal scholars are focusing on the long-term impact of the Rahimi decision on future challenges to various firearm regulations nationwide. Individual rights remain a cornerstone of the American legal system, requiring a careful balance between safety and personal liberty at all times. Vigilance in monitoring legislative changes at both the state and federal levels is a primary responsibility for any engaged citizen today. Understanding the nuances of due process is just as important as knowing the specific statutes that govern firearm ownership and carry permits. The role of the judiciary is to interpret the law as written while considering the historical context established by the Founding Fathers. Modern technology has introduced new challenges for the First Amendment, especially regarding how government officials interact with private tech platforms. Financial services are becoming a new front in the battle for civil rights, as seen in the recent Supreme Court rulings on pressure campaigns. Public safety arguments must be weighed against the explicit protections provided by the Bill of Rights to ensure a free and stable society. Every court case provides a brick in the wall of legal tradition, and these recent rulings are significant additions to that structure. The clarity provided by the Supreme Court helps lower courts maintain consistency, even when the topics at hand are highly controversial. Staying active in your community and informed about local ordinances is one of the most effective ways to preserve your constitutional rights. Legal aid societies and civil rights organizations often provide resources for those navigating the complexities of firearm laws and administrative regulations. The debate over firearm policy is as old as the nation itself, reflecting deep-seated values regarding security, freedom, and the role of government. As we move forward, the legal community will continue to analyze every footnote and dissenting opinion for clues about future judicial directions. Corporate policies that mirror government agendas can sometimes cross the line into state action, triggering constitutional scrutiny and legal challenges. Protection against government overreach is the primary function of the First and Second Amendments, acting as a safeguard for all citizens. The burden of proof remains on the government to justify restrictions on fundamental rights using historical principles and established legal frameworks. Dialogue between gun owners and legal experts is vital for fostering a culture that respects both the law and individual constitutional protections. The evolution of the law is a slow process, but significant rulings like Rahimi and Vullo can accelerate change in specific legal doctrines. Preparation and education are the best defenses against unintended legal consequences, especially in the rapidly changing field of firearm regulation. History proves that rights not defended are easily lost, making it imperative for everyone to understand their legal standing under the Constitution. The importance of a fair and impartial judiciary cannot be overstated, as they are the final arbiters of our most cherished liberties. National conversations about rights often lead to legislative action, which then brings the focus back to the courts for final validation. Each citizen has a role to play in the democratic process, from voting to staying informed about the latest developments in constitutional law. Consistency in the application of the law ensures that all individuals receive equal protection, regardless of their political beliefs or background. The Supreme Court serves as the ultimate guardian of the Constitution, ensuring that no branch of government exceeds its delegated authority. A well-informed public is essential for the maintenance of a free society, particularly when it comes to understanding complex legal rulings. Future cases will undoubtedly build upon the foundations laid by Rahimi and Vullo, further clarifying the scope of our fundamental rights. Effective legal advocacy requires a deep understanding of both historical precedent and the practical realities of modern governance and law enforcement. The relationship between the individual and the state is constantly being renegotiated through the legal system and the actions of the courts. Liberty is a multifaceted concept that requires the protection of multiple rights simultaneously to be truly meaningful for the average citizen. Ongoing education is the hallmark of a responsible citizen who values the freedoms guaranteed by the Bill of Rights and the Constitution. The path forward involves a careful examination of how we balance collective needs with the inherent rights of each individual person. Ultimately, The power to protect our rights lies in our willingness to stay informed, organized, and active in the legal and political spheres. Final thoughts include the reminder that these rulings are just one part of a much larger and ongoing story of American constitutional law.